All right, so Mr. Johnson, we already kind of went through this, but in 24, hold on, let me get it pulled up right. 24 DCCR 2095, I'm in the wrong place. Sorry, you guys, I was on the wrong day looking at that other stuff. Give me just a second. And there was already a rejection done in the aggravated robbery for a 40-year term, and that has now changed to a 15-year offer. So, Mr. Johnson, in cause number 24, DCCR 2095, we've gone through this before. You're charged with a first-degree felony offense of aggravated robbery from September 7th of 2024. The indictment alleges you were previously convicted of robbery March 9th of 2015. What that means, if you go to trial and are found guilty, are there other priors as well?
There are priors, but not the enhanced.
So this wouldn't, he wouldn't be habitual,
He's not,
he would
he's
be,
not a repeat offender. I noticed that Mr. Wilkerson checked the box for habitual. It actually should be a repeat.
first degree enhanced.
Enhanced, that's right.
So what that means is that if you go to trial and you're found guilty in that case, and if that prior offense is true, you would be considered enhanced for punishment, which means the minimum would be 15 years up to 99 years or life. Do you understand?
Judge, give me just 1 second.
Yeah. Anna, I don't know how, this is not erasing. I've pressed. Now it did, just because I said that. Let me double check that there weren't. Because in December of 2024, there was something filed that is the state's notice of intent to use prior convictions to enhanced to habitual. We've got the robbery conviction from March 9th of 2015 and an evading arrest or detention with previous convictions. So that's the misdemeanor that was enhanced. Do you think that that's a state jail felony, right? An evading arrest that's enhanced is a state jail.
I looked at that. I think I even talked to Corey even about it. I don't think we'll get there with that.
Okay, all right, so that's what it looks like was filed, and so it looks like, in fact, if those are the two prior offenses, it would be a first-degree enhanced punishment, again, with a minimum of 15 years up to 99 years or life. Do you understand? And then, in cause number 25, DCCR 1626, hold on a second, let me find it. 1626.
I think the habitual offender box is checked on that one too.
Yeah,
It should just be a repeat offender.
I could have sworn there was more than one greater than state jail. So that's why I'm double checking.
Yeah, no, go ahead. I'll give you a minute to do that. I'm just looking at what was filed, and it looks like the second one was, in fact, just a state jail.
Possession of state jail, evading prior state jail.
You want me to roll that one? Oh, it's not there, okay, that's it.
Let's see. That one.
It's not, it's gonna go, those convictions. Yeah, they work. That's why I was wanting to talk about that.
Sorry, Your Honor. I'm making a mistake, and I only see in the original indictment on the aggravated robbery that one felony that is above the state jail level. So if I'm wrong, then that's better for my client. I just I'm
The court in Needham was of the opinion that we could not use a evading arrest that had been enhanced to further enhance this.
Yeah, I think that sounds correct to me as well. And so, in the clause number 25, DCCR 1626, you're charged with unlawful possession of a firearm by a felon. And that's from October 9th of 2025. And what that means, it has the same prior offense conviction listed as well. And what that means in that case is, again, the habitual, it's not habitual, it would be enhanced first degree, which means the minimum punishment would be 15 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
No, I'm just, do you
No, I'll say yes,
the
ma'am.
question is, do you understand?
Yes, ma'am, I say yes, ma'am.
Okay. And so I have in both of these cases new plea bargain rejections that you've signed with Mr. Wilkerson's that shows that the district attorney's office has made offers, if you wanted to enter plea of guilty, for 15 years in each case to run concurrently. You have every right to reject that and have a jury decide. And so is that what you want to do, is reject that and go to trial?
Just before he answers that, I just want to make sure, maybe I misheard on the unlawful possession of a firearm with a felon, or by a felon. My understanding is it starts out as a third-degree felony, and is enhanced
To a second. I messed that up as
So
well.
it'd be
Missed
2 to
both.
20.
So it would be 2 to 20.
Sorry. All right, let's get on the same page. I'm so sorry. You're correct. So that was, we all messed up on that one. And now okay. Unlawful possession of a firearm by a felon, third degree felony. The prior conviction is for robbery from March 9th of 2015. If you go to trial on the unlawful possession of a firearm and you're found guilty and that prior conviction is true, it would only enhance to a second degree felony, which is between 2 years and up to 20 years in prison. Do you understand that?
Yes, ma'am.
Okay, so the possible punishment ranges on each of these: on the unlawful possession of a firearm by a felon, 2 to 20. On the aggravated robbery, 15 to 99. You understand? The offer is 15 years on each of them to run at the same time concurrently. Again, you have every right to reject that. Is that what you want to do?
On the unlawful carry, I didn't, but I didn't want to take the aggravated
I
robbery
don't,
side.
so here's the
Yes,
thing.
ma'am. Yes, ma'am.
We're gonna go
I reject it.
forward on whichever, we'll set them both for trial.
Yes, ma'am.
And it will be the state's election on which one to go forward on first. If they elect to go on that unlawful possession, that's what we'll go forward on. We'll get the other one taken care of as quickly as possible also. I just wanna make sure you don't wanna take this deal today. Okay, then
Judge.
we'll get the cases set for trial on the next available trial docket.
I do want to mention, just for record purposes, again, we do have that motion for speedy trial pending in that older aggravated robbery charge. So if the state does elect to proceed on the new indictment, we'll be asking for a dismissal of the aggravated robbery based on the fact that they decided to try a new case as opposed to granting the speedy trial request of the defendant.
Well, I'm gonna get them both set as speedy as possible. Obviously, you guys know that there's nothing lagging over here as far as getting trials set. If something happens on that date and you think legally you have something to file, we'll take care of any legal issues when that comes up. All right? All right, you can go back with the bailiff.
Thank you.
Thank you, Your Honor.
Thank you so much. No.
messing
Don't
everything
touch it
Why?
because they're electronic. And we'll fix it from over here.
Oh, it's electronic?
All right. Please, ma'am. It's fine. Mr. Nichols, would you like to be on the screen?
I don't care, Judge. This is where I am every day.
All right. Okay, sir, are you Terry Rose?
Yes, ma'am.
Mr. Burbank, will your client waive the formal reading of the indictment?
You will.
Mr. Rose, in cause number 24, DCCR 1369, you're charged with the first-degree felony offense of murder from July 9th of 1999, and how do you plead to that charge?
Guilty?
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Sort of. Yes. Yes. Okay.
No,
Yeah.
we're not playing, hold on.
Yes.
Listen to my question. You answer my question. Mr. Burbank, I'm not questioning you. Did you do what they charged you with in cause number 24, DCCR 1369?
Yes.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
All right. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Okay. Oh, did I?
Did you go over them with him? The documents that
Oh,
you
the
signed on the
documents?
tablet?
Yes, he explained them and I signed.
And do you
I did.
fully understand them?
Kind of, I'm not a law person, but
What do you not understand, Mr. Rose?
most of it, but it's okay.
No, it's not okay.
Oh. I read-
Mr. Rose,
Yes, ma'am.
this is not a game.
I'm not playing a game.
We're about to go to trial next week, okay? I don't have to take this plea agreement. We can go to trial. We can let a jury decide. If you didn't do it, if you sort of did it, or whatever you're trying to say, we're not playing games. There's too many people involved in this situation that have waited too long for this day and for next week. We've got a jury coming. There's no reason for us to be doing this deal today unless you actually did it and take full responsibility. Because if you don't, then what I don't want to happen is when I get the pre-sentence report, and if you don't take responsibility, then I'm going to reject the plea agreement and we're going to be right back here. So I'm inclined right now, based on this, to probably reject, and let's go ahead and go to trial next week is what I'm thinking. So,
Your Honor, my understanding is that he intends to present some evidence at sentencing that he feels may lend to a either sudden passion charge or some mitigation. I think that's where that hesitancy is coming in, Your Honor.
okay. But so is it just going to be for mitigation under the first degree felony? It's
Yeah.
not some sentencing trying to get a sudden passion ruling?
No, it's he's pleading to murder, and within the code, then I can argue, or we can argue, for sudden passion after the conviction of murder.
That's what I'm asking though, is so what I'm saying is, when we come back for sentencing, you're going to be arguing a legal issue, not just for me to sentence at the cap of 40, you're going to be asking for me to consider
Something
making a
less.
finding, not just say, listen, not just something less. Are you asking me to make a finding of sudden passion, which would reduce it to a second degree felony is my question.
If you deem that it was appropriate.
But that's what you're going to be asking for on sentencing. I think that's what a jury should do. And that's your understanding?
Yes, Your Honor, I have no problem with that. I don't expect that. I expect to present evidence that'll make the court's decision easier.
So it'll be a whole sentencing hearing, trial type for sentencing alone. If we're going that far, we'll have several witnesses, I'm assuming.
I will be calling several witnesses, yes, Your Honor.
Mr. Burbank, I guess you would have to at least call someone for the sudden passion, your client, or,
Either that, or it could be outlined in the PSI report, Judge.
no, if we're going to do it at a hearing, I would need actual testimony legally in order to, if whether it was a jury or the court, in order to make a finding of that. So that'll be up to you guys. Okay. So let's go back then to the paperwork, Mr. Rose. Tell me anything that you went over that you don't understand in this paperwork.
Well, I just didn't read all of it. I do understand what it means, or what it's gonna mean.
Okay, so do you understand that the agreement that you've reached is for a cap of 40 years in prison?
Yes, ma'am.
And what that means is you're leaving your punishment up to me. I can give you 40 years, I can give you less. It depends on all the information that's brought to me at that sentencing hearing, including any witnesses and a pre-sentence report. You obviously have the right to let a jury determine two things, if you're guilty or not. And then if they decide if you're guilty, you can leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation exclusion from admission to the country, or denial of naturalization under federal law?
Yes, but I'm born here.
I'm required to ask everyone that.
Oh, well, okay.
And I just want to make sure, I know, Mr. Nichols, you're obviously in contact with the family.
Yes, Your Honor.
Do they know that this is taking place
I
this
informed
morning?
them shortly, once I found out this was taking place.
Okay, and they are ready and prepared and
Yes, sir.
want to go forward with this morning?
Yes, sir.
Okay. State tenders number 1.
Just for the record, Judge, because I want to make sure it's clear. I have gone over it and explained all the paperwork to Mr. Rose. Mr. Rose, I have answered all your questions, correct? Yes. You have asked me questions in reference to taking this plea, correct? Yes, sir. And I have satisfactorily answered all the documentations that you signed here today to your satisfaction. Yes, sir. No one is making you plead. You're doing this freely and voluntarily. No, I'm doing this voluntarily.
Thank you, Mr. Burbank.
And I have no objections, States One.
Thank you. States 1 is admitted. Is there any evidence that Mr. Rose is not competent?
No, Your Honor.
And actually, with regard to that, I do believe that there.
He was evaluated previously, Your Honor.
So I will take judicial notice of the court's file, and Mr. Rose was previously evaluated for competency to stand trial. That was done by Dr. Grapon. We received that report back in May of this year with the finding that Mr. Rose was competent to stand trial. Any other issues with regard to competency?
No, Your Honor, I did that out of precaution. I requested it. I did that out of precaution, not that I saw anything, but because of the length of the case, the nature of the case, I want to explore every possible defense that Mr. Rose might have had.
All right, then I will, again, I know I already said that, but I will find Mr. Rose competent and that he entered his pleas freely and voluntarily. And so at this time, Mr. Rose, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case, a short reset, to get the probation department to do a pre-sentence report. We'll come back for sentencing. I think it's looking at like the afternoon of the 16th. We'll have at least 3 hours or so for anybody to put on any evidence that you want to with regard to sentencing. And the pre-sentence report, probation officers has let us know that they will be willing to get that done quickly. Get with you, Mr. Burbank, if you'll make an appointment with them. You guys could go out, you could be there for his interview, and then we'll move forward with sentencing. If something happens and y'all feel like for some reason we need more than that amount of time, let me know and we'll see what we can do. But for now, we'll plan on doing it let's do this. Let's say 2 o'clock. We may not get started till 2:30, but if that hearing is over quickly, which I anticipated, we can go ahead and get started, and that gives us that full afternoon on the afternoon of Tuesday, the 16th.
Excellent.
All right, you can go back with the bailiff.
Thank you, Your Honor.
Yes, sir. Thank you, Mr. Burbank. Thank you, Judge Thorne, also for trying.
You're welcome.
We have one new judge with 2 and 2.
Okay. Let me see here. I'm gonna write these real quick. Anna, would you print the MTRP on 1199, please? And I'm gonna print the other one real quick. Give me just a second. All right, give me just a second. All right, so are you Kevin Damon Ross?
Yes, ma'am.
And will your client waive the formal reading of the indictment and the motions?
You will in all three.
Mr. Ross, in cause number 251310, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 13th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents in that case that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection, Storm.
it's admitted. Is there any evidence that Mr. Ross is not competent?
No, Your Honor.
Let me look at something real quick. I'm printing something else. Sorry, I'm trying to find the pre-sentence report real quick in the,
The underlying.
I think I've got it probably in this case. I think I was looking at the wrong one. Yeah. Obviously, I'm looking at not 11, how quickly he reoffended with the same thing, and truly the outlandish way
Yes.
in which he did it.
Judge, we had an honest discussion about the fact that the court might reject that. If so, that would be completely understood, and we would be happy to go back and discuss it further. And at that point, it may be best to just go open on the MTRPs and allow me to prove up all of those administrative violations. That way you have everything kind of at your disposal. He doesn't have any felony criminal history, but obviously the new offense was egregious as well as the underlying. So Mr. Burbank and I would have discussed that.
I don't see the PSI in either of mine, Anna. Maybe I'm missing it. But Ms. Malfino had it, but I'd like to see that entire PC. I mean, see why it's not there. Yeah, so the first time in March of last year, that offense, sorry, I'm just trying to get a look at the whole picture. Give me a
Here's the
second.
PC on the new offense.
I've got that already. Thank you. This is the one I need to. All right, I'm printing one more thing as well. I can't, the PC's come up on my computer looking like a foreign language. So the first offense that you're on probation for, there was a actual accident. Okay, and then the new offense starts in Port Arthur. I mean, 127 miles an hour or more.
I question that, Judge, because I did see the video. And I don't think that car could go 107 miles an hour.
It's a pretty specific speed for the cops to
Well,
be
that's
saying.
probably what he had to do in order to catch up to him.
Nearly struck other motorists, splitting the lanes. Had to advise DPS, Jefferson County, Port Arthur, Groves, Nederland, because he's going all over the place. Blacking lights out. Yeah, no, I'm not going to accept this agreement on the motions. I'm going to delete the paper. Well, we can do a couple things. We can either go forward. Let me get pleas on the motion of true or not true. If he wants to plead not true, we can have a hearing. The state can bring evidence. If he wants to plead true, I'll get an updated pre-sentence report and we'll have a hearing on sentencing.
I'm gonna have to ask that you withdraw everything, Judge, and give me a little bit of time so I can try to figure something out.
Sure. I do want, sooner rather than later, to go through the motions and get pleas of true or not true. So at least that moves the case forward, because once we do that, then we're going to still reset it for a hearing.
If you just give me a couple of weeks, or a week and a half, I mean, depending on what happens.
Let's set Mr. Ross on Tuesday the 16th. We're going to be busy on Tuesday the 16th, and I'll delete all the paperwork and withdraw everything. You can go back with the bailiff. So I really don't know if I need. Good morning. Are you Gerald Downs?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case? Would you fill in the dates on those for me, please, ma'am? All right. Mr. Downs, in cause number 24, well, let's see, what counts are we going on? Count one only?
On count one only on
All right, let me get that pulled up properly. Is that in both cases?
Yes, Judge.
Okay, thank you. All right, and cause number 24, DCCR 0566, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from January 28th of 2023, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
Give me a second to pull the other one up. Sorry, it takes a minute for me to pull it up the right way so I can make those notations. All right, and cause number 24, DCCR 1023, the state's also elected to proceed on count one only. It alleges you committed the third-degree felony offense of deadly conduct discharging a firearm from January 28th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily? And because you did what they charged you with. In each of these cases, I have here on the tablet some documents that have your signature on them. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tender's number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Downs is not competent?
No objection.
All right, Mr. Downs, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 24, DCCR 0566, find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1023, also find sufficient evidence to find you guilty, and at this time find you guilty of deadly conduct, discharging a firearm. Sentence you in accordance with that agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certification in each case that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. It's my understanding, is there already a federal sentence that you're
It's
serving?
already been sentenced.
So did they specifically
They said that it would run according to.
concurrently?
Concurrent.
Okay.
According to.
So I will also order that it's really up to the federal system on whether things run concurrently or not with state. I can say whatever I want, and they're going to do what they want. It's my understanding, though, that they've said that this will run concurrently or at the same time with your federal sentence, and so I will make sure that our judgments notate that as well, so that both of these will run concurrently with each other and the federal sentence. If there's something different that happens on that, that's up to them. Okay? All right, you can go back with the bailiff. Good luck to you, sir.
Thank you.
Yes, sir. Let's see, Gregory Griffin. Good morning. Are you Allison Strom?
Yes, Your Honor.
And Mr. Parker, will your client waive the formal reading of the indictment?
No, Your Honor.
Ms. Strom, in cause number 25, DCCR 1370, you're charged with a second-degree felony offense of assault on a peace officer, and that's from August 23rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 3-year deferred probation. You would be on specialized caseload for any issues that you have going on, and then required to follow all of the other rules and conditions of probation. Is that your understanding?
With community service, correct?
Community service, reporting, drug testing, anything through MHMR, mental health treatment, anything like that, you will be required to do as part of your probation. Do you understand?
Yes, Your Honor.
Okay. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number
No
one.
objection.
It's admitted. I have to ask everyone that about the citizenship.
I'm American.
Everybody.
I had no doubt you were, but I have to ask everybody, okay? States number one's admitted. Is there any evidence that Ms. Strom is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing.
She's requesting a personal bond just because she doesn't have the means to bond down.
Judges, if I may,
And she, and I'm sorry, I think she wanted to go to live in Houston
Yes, sir.
with her,
Mom.
her mom in Houston.
and that would obviously be a better place for her than maybe here in Beaumont. I don't know if the court is familiar with the probable cause. I have it here, so as not to really embarrass her in open court. There were some issues. The officers were trying to effect an emergency detention arrest for her own safety because there was some mental episode of sorts going on. And so my concern is that she would immediately go to MHMR or immediately go to her mom's house and remain there effectively under house arrest until some sort of evaluation and help for her can be put in
Right.
place so that she doesn't harm herself.
I guess my concern is during that period that she's not on probation, I'm not sure what access she has to Spindletop without it being court ordered.
Where does she be living?
Well, she's wanting to go live in Houston with her mom, and so I would want services obviously there. So that wouldn't be Spindletop, it would be Harris County, I can't remember.
They do have one.
I just don't know, it would be a condition of probation, but not a condition of bond. I don't think I can, so that's my concern.
Yeah, you are. Yeah, you're, the judge can, yeah, but you just requested you live with your mom, but she says, she may have a place in Belmont she could live on.
Well, here's what I'm worried about is if I let you out on bond before we order probation and we have the conditions in place so that you can receive the treatment that you need, I need you receiving some treatment between now and then.
Sorry.
Go ahead, yeah, tell me.
I have a prescription I have the full prescription currently. Some of it's in security and then some of it's at my mom's.
Okay,
That was part of the issue. She wasn't taking her medication when this happened.
okay. So you understand obviously at this point that you have to take the medication.
ma'am.
No matter how it makes you feel, good or bad, you have to take it.
No, I've been taking it every day while here and consecutively for the 2 months.
Good.
I've noticed a difference.
You feel better.
I feel I have a little bit more hope.
Good. So, all right, so here's what I'm going to do. I'm going to reduce your bond to $1,000. I'm going to make it a personal bond, which means you don't have to pay money. So you're just going to be released today.
Yes, ma'am.
But I'm going to I want you to go live with your mom. If that's the best place for you, you have medication there, she understands what's going on. So you're ordered as a condition of that bond to continue taking your medicine.
Yes, ma'am.
You're ordered to go live with mom.
Okay.
You need to make sure you know how to get in touch with Mr. Parker. If something happens and it doesn't work out with mom and there's somewhere else that you need to go, you need to let him know so that I can give you permission to go there.
Yes, ma'am.
Okay? Also, you're going to have to go to the probation department here as soon as you're released so they can start that pre-sentence report.
Do
Okay?
I go today?
Today, it depends on what time that you get out. So if you get out before 5 o'clock today, then it's better to go straight there today. If not, you'll go first thing tomorrow morning. Today, you're going to get some paperwork before you leave court today that has the address, where you're supposed to go, and everything. So don't leave and go to Houston before you take care of that appointment.
I have somewhere I can stay for the night.
Okay, perfect. All right, any other questions? We're good? Okay, we'll see you back at sentencing.
There's 3 cases, Judge. I did a separate one for all of them, but the Senate, the plea The offer was all the same on all of them, just using different levels.
All right, so are you Robert Earl Trahan?
Yes, ma'am.
Mr. Trahan, in cause number 25, DCCR 1094, you're charged with the state jail felony offense of unauthorized use of a vehicle. The indictment alleges that you were previously convicted of accident involving injury or death, a special felony on October 16th of 2017. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, October 17th of 2022, and also possession of a controlled substance, a second-degree felony on that same day. What that means in that case is that if you're found guilty and those prior convictions are true, the punishment would be enhanced to that of a second-degree felony. So it would be a minimum of 2 years up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1317, you're charged with possession of a controlled substance, a state jail felony, from December 28th of 2024. It alleges those same prior offenses. And so in this case, also, if you were found guilty and if the those prior convictions were true, then you would be enhanced to second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then finally, oh, wait, hold on. In cause number 25, DCCR 1536, you're charged with a third-degree felony offense of, evading arrest or detention with the use of a vehicle from August 20th of 2025. The indictment alleges those same prior offenses, which in this case means that you would be considered a habitual offender with a minimum punishment of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
In all of these cases, I have here on the tablet the plea bargain rejections that you've signed with Mr. Parker. This shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for 10-year terms in all of those cases. And so that would mean in that last case, the evading going on count one only for the 10-year term to run concurrent, all three of them. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes.
And Mr. Coleman, is there any reason to anticipate that there's any other evidence that you haven't received that would change that offer?
Not at all, Your Honor. In fact, the state will be filing a motion to accumulate the sentences in all three of these cases.
So I do want to make sure you also understand because these are different offense dates, there is the potential, if you're found guilty in all three of the cases, that any sentence that you received from a jury could be stacked on top of each other. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this plea agreement. You understand?
Yes, ma'am.
All right, then I will get your cases set on the trial docket. Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation a little quicker. Is that okay with you? All right, Mr.
Your Honor, as I've told the court, he has Brian Matuska as a parole lawyer, and he would be fine with Mr. Matuska, but, it's obviously up to the court.
I'll take a look at it. Typically, it's just a rotation. If Mr. Matuska is already handling something for you, we'll contact him, and if that works out, we'll appoint him. If not, then it'll just be somebody off the rotation.
Yes, ma'am.
Okay, you can go back with the bailiff. Good morning. Are you Paul McCorvey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does.
Mr. McCorvey, in cause number 24, DCCR 1914, you're charged with the state jail felony offense of theft of property from July 3rd of 2024. And how do you plead to that charge?
Guilty, I guess, non-guilty, no contest, whatever. Guilty.
Either you did it or you didn't do it. Are you guilty or are you not guilty?
I guess guilty.
There's no I guess. Here's the thing. If you're not guilty, we can set your case for trial. A jury can decide if you're guilty or not. If you're guilty and you want to take this agreement, then you have to plead guilty, but you also have to take responsibility. It's not just going through the motions and saying, I'm pleading guilty, but I didn't really do it. So, to the charge of the state jail felony offense of theft of property, how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yeah.
And are you pleading guilty because you actually did what they charged you with?
Yeah, I guess so. Yeah.
You're about to get your case set for trial.
No, ma'am, I did it. Yeah.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred probation. There would not be a fine. There would be restitution ordered in the amount of $2,500, and you would be required to follow all of the other rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. McCorvey is not competent?
No, Judge.
And Mr. Nichols, since we have that restitution and
Judge, I would
it's a
ask
state
that we
jail
go forward today.
with sentencing.
Yes, Your Honor.
So what I'm going to do, Mr. McCorvey, is waive the pre-sentence report, and we'll get a post-sentence report. And order, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation. Was it 4 years? Sorry, my computer's locked.
Yes, Your Honor.
For a period of 4 years. You're ordered to pay $2,500 in restitution and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, then the case will actually be dismissed at the end. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand? It's very important to me and obviously to the victims that that $2,500 gets paid. So I want you to start making payments on it immediately.
As soon as I possibly can. Yes, ma'am.
And another thing that can happen is if you get that paid off and you do everything you're supposed to on your probation, get your community service done, fees, fines paid, do everything right, it's very likely that you could get off probation early.
I have community service on this also?
Yes, everyone on probation, it's required by law that you have community service. And so they'll let you know what that amount is. But the sooner you get everything taken care of, if you do it all correctly from the beginning, you can get off. I sign early terminations all the time. But you have to do it all correctly, otherwise you'll do the whole time, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. Maribel Reichel? Good morning. Are you Zurich trustee? Mr. Trustee, in cause number 25 DCCR 0981, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 19th of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 25 DCCR 0982, you're charged with a first-degree felony offense of aggravated robbery from June 19th of 2025. What that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand? I have here on the tablet in each of those cases plea bargain rejections that you've signed with Mr. Parker that shows that the district attorney's office has made offers in each of your cases. Hold on a second. For 15-year terms in prison that would run concurrently, which means together at the same time. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that? And do you want to reject those offers and have your cases set for trial? And Mr. Coleman, is there any reason that the state, is it any evidence you're waiting on or any reason to believe that those offers would change?
We don't anticipate any additional evidence, and there is no inclination or any information that we anticipate that would affect the offer that we made in this case.
So, Mr. Trustee, I want to make sure you understand, after today, when your case goes on the trial docket, I will not accept these plea agreements after that. You could change your mind, plead to a different number, or plea open to the court, but it's not going to be to the same offers. Do you understand?
And Your Honor, just for the record, last time we reset because there was a video that somebody provided me, and we had them come up here, and they provided that to the DA's office, or ultimately to the police station. And just so he knows that Mr. Coleman is aware of that video, but it's not changed his offer. Or,
Okay.
well, I say video as a message.
Okay.
That's correct.
Okay, perfect. So, Mr. Trustee, I'll get your case set for trial. Mr. Parker has been appointed to represent you at this time. He's one of the attorneys who represents a lot of defendants here as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, speak up, please. All right, so Mr. Parker, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial. Okay?
I have videos. You want to turn those to the court, or?
Yeah, if you will, hand those to the clerk. If you'll make a notation, whoever we appoint, make sure they know we have them and they can come get them from our office. You can go back with the bailiff. Thank you,
Thank you,
Mr. Parker.
Oh, Your Honor, he's was wanting me to ask the court about the bond reduction. I think it's bond to it.
I'm not
We
gonna,
ask for time.
yeah, well, nothing's been filed for a bond reduction. You can talk to your new attorney about filing something, and I'll set your case for a hearing as soon as that gets filed. Mr. Wilkerson, you have Romeo Johnson. Good morning. Are you Quincy Batley? And will your client waive the formal reading of the indictment?
He would.
Mr. Batley, in cause number 24 DCCR 1295, you're charged with the third-degree felony offense of unlawful possession of a firearm by felon from June 28th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection to it.
It's admitted. Is there any evidence that Mr. Mallett is not Mr. Batley is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff. Yeah.
Well, he didn't have anything to write on, so.
Right. All right, ma'am, are you Lauren Bridges? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Bridges, in cause number 25 DCCR 0354, you are charged with a state jail felony offense of credit or debit card abuse, and that's from October 16th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Bridges is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing, and so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. I'm assuming, based on the plea agreement, that there's some type of history, Mr.
Judge, I'm
Nichols?
showing, I think, 2 prior state jail probations that I don't see a revocation for. Looks like they were both completed successfully.
And Your Honor, I provided, we originally set for a bond here. I provided the court and the state with letters. There's 4 letters. She voluntarily went to rehab from August. She got out October 27th. She immediately turned herself in when she got out. And I have those letters. There's 4 different letters from, it's called Riverwalk Ranch. It's where she received her treatment. Of course, she got certificates of completion, things like that.
All right, so any objection based on all of that and the nature of the plea for a bond, a low bond or
No,
PR
no
bond?
objection to it. Yes, I want Your Honor.
What was your drug of choice, alcohol or some drug?
It was alcohol, methamphetamine.
Both, okay. So here's what I'm going to do. I'm going to reduce your bond. I'm not going to make it a PR bond because I'm going to order a drug patch. I'm going to reduce your bond to $1,000 based on the nature of your plea agreement. Condition of that bond is that you have to have a drug patch on within 24 hours of your release. So if you make the bond, talk to your bondsman, they'll let you know where to go get a drug patch on. Obviously, if you test positive for anything between now and sentencing, you run the risk of me not accepting this plea agreement. Things could be much worse. Also, if you make that bond, the first thing you do is go to the probation department so they can start that pre-sentence report. If you don't do that, you run the risk of me raising your bond and me not accepting the plea agreement. The last thing is that if you are arrested for anything between now and sentencing, if you make that bond, obviously you run the risk of me not accepting the agreement. You understand?
Yes.
Okay, we'll see you back at sentencing. You can go back with the bailiff.
Thank you, Your Honor.
To have a mental examination, so he's in jail right now.
All right, sir, are you Travis? Hold on, are you Travis Smith?
Yeah, I'm good.
So I know there have been some documents filed by Mr. Adams with regard to a mental examination. I think there was some confusion as to what you're asking for. First of all, you're hired in the case, correct?
Yes, ma'am.
So anything that is filed requesting a court-appointed examination needs to include an affidavit of indigency, sworn to. So I need you to get that taken care of and attached to anything you filed if you haven't already.
Well, it's not indigent, so we might have to
Okay.
take up part of it. I'm not gonna follow that.
Okay.
For that reason,
Okay, I mean, there are times when someone can
Yeah.
hire an attorney,
Yes.
but they run out of
Yeah.
money or whatever it is. If that's not the case and he's not indigent, then I'll reset the case to give you a time to have someone get that examination taken care of. But if it's a hired case and they're not indigent, that would be something that the defense would take care of. So,
well, I
did you-
could still have, I think I have an order that would, allow that. Let me look through it here. I wrote the order different ways.
I guess what I'm saying is I'm not going to sign an order having the county pay for it unless there is an affidavit of indigency.
I'm not asking for the county, that's what I'm saying. I have an order where we do it.
Well, I don't know that, I mean, I'll order, but I don't know that you need me to order it. If it's your client, you can have him examined. Is there, you know what I'm saying? Do you need me to order it? If it's
No,
your,
I can get him examined for, it's present competency.
okay. But I don't think I need to order it. I think you can just have a doctor go, if that's
Or a
between,
PhD can do it too, I think.
yeah,
Yeah,
yeah. So I'll reset it to give you some time to get someone to go out there and take care of whatever examination that you need to, and then we'll get an announcement at the next court date.
okay, but what are we what I want after that is, to put him somewhere where he can't afford this.
Well, we got to get the
State
examination.
hospital,
Let's take
yeah.
one step at a time.
Yeah,
Let's get
that's
the
the second.
let's get the evaluation
All right, well,
done,
this is the
because if
first
he's
thing.
not competent, then I can order
Yeah,
him go to the appropriate facility. All right? All right, so you get the examination taken care of.
have to get you examined to make sure you're confident in what's going on, but huh?
A doctor is going to come visit with you and just talk to you about your case and what's going on and make sure you understand everything, and then we'll go forward after that, okay? Because that's what we're going to take care of. That's what your lawyer is recommending. So that's what we're going to do. So you can go back with the bailiff. Mr. Adams, the quicker you get that done, the better, so that whoever's going to do it can get out there and get that taken care of.
This docket transcript highlights the critical role of judicial oversight in ensuring transparency, precision, and voluntariness within the plea bargaining process. Managing a series of serious felony cases, ranging from aggravated robbery and firearm possession to a 1999 murder case and high-speed evading arrest, the judge meticulously clarifies sentence enhancements, punishment ranges, and rights to appeal. The judge's reasoning is anchored strictly in procedural integrity and public safety. She actively refuses to accept a reckless driving plea deal upon reviewing the defendant's egregious conduct, and firmly rejects a murder plea when the defendant admits he did not read the paperwork, emphasizing that the court is not a place for games. The attorneys continuously collaborate to correct statutory calculations, while the defendants must choose between negotiated terms or going to trial. For viewers, the broader lesson is that a plea agreement is not a rubber stamp formality. It requires a complete understanding of the terms and absolute accountability, under the watchful eye of a court dedicated to formal justice.
The court session opens with the case of Romeo Johnson, whose matters involve 2 separate felony charges and a complicated discussion about prior convictions and punishment enhancements. The judge begins by revisiting cause number 24, DCCR 2095, an aggravated robbery case stemming from September 7, 2024. She explains that Johnson is charged with a first-degree felony, and that the indictment alleges a prior robbery conviction from March 9, 2015. The central issue becomes how that prior conviction affects the punishment range if Johnson goes to trial and is found guilty. The court and counsel work through whether he should be treated as a repeat offender or as a habitual offender, and whether another prior conviction for evading arrest, which had itself been enhanced, can be used to increase punishment further. The judge pauses several times to review the file, while counsel notes that if the court is mistaken about the enhancement, that would only help the defense. After discussing the state's notice of intent to use prior convictions, the judge concludes that the aggravated robbery would carry an enhanced first-degree punishment range of 15 years to 99 years or life if the prior robbery conviction is proven. The conversation then shifts to cause number 25, DCCR 1626, an unlawful possession of a firearm by a felon charge from October 9, 2025. Initially, there is confusion about whether that offense would also be enhanced to a first-degree punishment range, but defense counsel interrupts to clarify that unlawful possession of a firearm by a felon starts as a third-degree felony and, with the prior robbery conviction, would only enhance to a second-degree felony. The judge acknowledges the error, states that everyone had been mistaken on that point, and correctly explains that the firearm charge would carry a punishment range of 2 to 20 years, while the aggravated robbery remains at 15 to 99 years or life. She then advises Johnson that the district attorney's office has offered 15 years in each case to run concurrently. Johnson has signed plea bargain rejections, and the judge carefully confirms that he understands the risks of trial, the ranges of punishment, and the state's offer. Johnson declines to accept the offer, and the judge sets both cases for trial, noting that the state can elect which case to try first. Defense counsel places on the record that there is a pending speedy trial motion in the older aggravated robbery case and argues that if the state proceeds first on the newer firearm case, the defense may seek dismissal of the aggravated robbery matter on speedy trial grounds. The judge responds that both cases will be set as quickly as possible and that any legal issues can be addressed if they arise later. The next significant case involves Terry Rose, who appears on a murder charge dating all the way back to July 9, 1999, under cause number 24, DCCR 1369. Rose indicates that he wishes to plead guilty to murder, a first-degree felony, but from the start, the plea colloquy becomes tense because the judge is not convinced that he fully understands what he is doing. Rose says he is pleading guilty and that he did what he was charged with, but when the judge asks about the paperwork, he admits that he did not really read all of it and only kind of understands it. The judge immediately stops the proceeding and makes it clear that this is not a game. She emphasizes that the court is on the verge of going to trial the following week, that a jury has already been summoned, and that many people have been waiting a very long time for the case to be resolved. She states that she does not have to accept a plea agreement and will not do so unless Rose truly understands it and is taking full responsibility. She warns that if she later receives a pre-sentence report showing that Rose does not accept responsibility, she will reject the plea agreement and put the case back on the trial docket. Defense counsel explains that Rose's hesitation comes from a desire to present evidence at sentencing that might support mitigation or possibly a sudden passion argument. That prompts the judge to press the issue further. She wants to know whether the defense plans merely to present mitigating evidence within the framework of a murder conviction, or whether counsel intends to ask the court to make a legal finding of sudden passion, which would reduce the punishment range to that of a second-degree felony. Counsel candidly admits that if the court deems it appropriate, the defense may indeed ask for a sudden passion finding at sentencing. The judge questions whether such a request should be decided by a jury rather than through a plea agreement followed by a contested sentencing hearing. And she points out that if the defense intends to pursue sudden passion, the sentencing hearing will essentially become a mini-trial with witnesses and testimony. Counsel agrees that he would need to present actual testimony, either from Rose or other witnesses, because a sudden passion finding requires evidence. After clarifying the defense's intentions, the judge returns to Rose and asks him specifically what he does not understand in the paperwork. Rose responds that he did not read all of it, but that he understands the practical meaning. The judge then carefully explains the agreement. Rose is pleading guilty to murder with a sentencing cap of 40 years, and he is leaving punishment entirely to the court. She can sentence him anywhere up to 40 years after reviewing the pre-sentence report and hearing testimony from witnesses. She reminds him that he has the right to let a jury determine guilt and punishment, and that by proceeding with the plea he is waiving those rights. Rose says he wants to proceed. The judge also confirms that the victim's family has been notified and is prepared for the plea to go forward that morning. Defense counsel places on the record that he has gone over the paperwork with Rose, answered his questions, and that Rose is pleading freely and voluntarily. The court then addresses competency. Counsel notes that he previously requested a competency evaluation as a precaution because of the age and seriousness of the case, though he did not personally observe incompetency. The judge takes judicial notice of the file and states that Dr. Grappon evaluated Rose in May and found him competent to stand trial. With no evidence of incompetency, she finds Rose competent, finds that the plea was entered freely and voluntarily, and finds sufficient evidence of guilt. However, she does not sentence him immediately. Instead, she resets the case for a sentencing hearing after the probation department completes a pre-sentence report, scheduling several hours on the afternoon of the 16th to allow the defense and state to present evidence relevant to punishment and any mitigation arguments. After Rose, The court turns to Kevin Dean Ross. Ross is charged in cause number 25-1310 with evading arrest or detention using a vehicle, a third-degree felony arising from June 13, 2025. Ross pleads guilty freely and voluntarily, confirms that he reviewed and understood the paperwork, and acknowledges that by entering into the plea agreement, he waives his right to appeal if the court follows the agreement. He also answers the standard immigration admonishment. The state's exhibit is admitted, and there is no evidence that Ross is incompetent. But rather than immediately accept the agreement, the judge begins reviewing the broader context of Ross's criminal history and probation matters. She searches for a presentence report and probable cause documents, remarking that she is not loving how quickly Ross reoffended with essentially the same conduct. The judge reviews the facts of the underlying offense for which Ross was already on probation, noting that there had been an actual accident in that earlier case, and then turns to the new offense. The probable cause information reveals that the new pursuit began in Port Arthur and involved extremely dangerous conduct. According to the report, Ross drove at approximately 127 miles per hour or more, nearly struck other motorists, split lanes, and caused officers to coordinate with multiple agencies including DPS, Jefferson County, Port Arthur, Groves, and Nederland because he was racing across jurisdictions. The report also states that he blacked out his lights during the chase. Defense counsel attempts to minimize the alleged speed, saying he saw the video and does not think Ross's car could go that fast. But the judge is plainly alarmed by the conduct and says she will not accept the agreement on the motions to revoke probation. She explains that the parties have two options. Ross can plead not true to the allegations, and the state can present evidence at a hearing, or he can plead true, in which case the court will order an updated pre-sentence report and later hold a sentencing hearing. Defense counsel asks to withdraw the paperwork and have time to discuss the situation further with Ross. The judge agrees, but insists that she wants pleas to the motion sooner rather than later so the case can move forward. She resets the matter to the 16th, withdraws the paperwork, and sends Ross back without accepting the agreement. The next defendant is Gerald Downs, referred to in the transcript as Gerald D.S. He has two separate felony cases, and the state elects to proceed only on count one in each. In cause number 24, DCCR 0566, Downs is charged with evading arrest or detention with the use of a vehicle, a third-degree felony from January 28, 2023. In cause number 24, DCCR 1023, he is charged with deadly conduct by discharging a firearm, also a third-degree felony from January 28, 2024. Downs pleads guilty to both charges, confirms that he is pleading freely and voluntarily because he did what the indictments allege, and states that he reviewed and understands the paperwork. He also acknowledges that if the court follows the plea agreements, he waives his right to appeal, and he receives the standard immigration admonishment. With no evidence of incompetency, the judge finds that Downs entered his pleas knowingly and voluntarily, and that sufficient evidence supports findings of guilt. She then sentences him in accordance with the agreements to 6 years in the Texas Department of Criminal Justice on each case, with credit for time served. The two 6-year sentences are ordered to run concurrently. The judge further discusses Downs's existing federal sentence. She explains that while the federal system is not bound by what a state judge says about concurrency, it is her understanding that the federal authorities have indicated the state sentences will run concurrently with the federal sentence as well. She orders the state judgments to reflect that intention, though she candidly notes that federal authorities will ultimately do what they choose. She also gives Downs a written admonishment that, because of the felony judgments, he is prohibited from possessing a firearm or ammunition under Texas law and should consult his lawyer if he has questions about the duration or scope of that prohibition. The court then hears the case of Allison Stum, charged in cause number 25 DCCR 1370 with assault on a peace officer, a second-degree felony arising from August 23, 2025. Stum pleads guilty and confirms that she reviewed the paperwork with her attorney, understands it, and knows that if the court follows the agreement, she cannot later appeal. The agreement calls for 3 years of deferred adjudication probation on a specialized caseload, with conditions including community service, reporting, drug testing, and mental health treatment through MHMR or any other required services. The judge finds her plea knowing and voluntary and sets the case for sentencing after a pre-sentence report is prepared, but then the hearing shifts to a request for bond. Defense counsel explains that Stum wants to live with her mother in Houston and that such a move would be safer than remaining in Beaumont. He notes that the probable cause affidavit shows the officers were trying to place her under an emergency detention for her own safety because she was suffering from a mental health episode. His concern is that she should either go immediately to her mother's home or directly into treatment so that she does not harm herself. The judge's concern is that until Stum is actually placed on probation, the court's ability to order treatment as a bond condition is more limited. She worries about releasing Stum without some assurance that she will receive care and comply with medication. Stum tells the judge that she currently has a full prescription and that some medication is in property while the rest is at her mother's house. Counsel adds that Stum had not been taking her medication when the incident occurred. The judge speaks directly to Stum and emphasizes that she must take the medication regardless of how it makes her feel. Stum says she has been taking it every day while in custody for the past 2 months and has noticed a positive difference, saying she feels a little bit more hope. The judge responds sympathetically and decides to reduce the bond to a $1,000 personal bond, meaning Stum will not have to post money. She orders her, as a condition of bond, to live with her mother if that is the safest place, to continue taking her medication, and to stay in contact with her lawyer if living with her mother does not work out and another living arrangement becomes necessary. She also orders Stum to report to the probation department as soon as she is released so that the pre-sentence report process can begin, instructing her not to leave for Houston until that appointment is handled. If she is released before 5 p.m., she should go that same day. Otherwise, she must go first thing the next morning. The next defendant is Robert Earl Trahan, who has 3 separate felony cases. In cause number 25 DCCR 1094, he is charged with unauthorized use of a vehicle, a state jail felony, and the indictment alleges prior convictions for accident involving injury or death, evading arrest with a vehicle, and possession of a controlled substance. The judge explains that if Trahan were found guilty and those prior convictions were true, the punishment would be enhanced to a second-degree felony range of 2 to 20 years. In cause number 25 DCCR 130-117, he is charged with possession of a controlled substance, also a state jail felony from December 28, 2024, and the same prior convictions would again enhance the punishment range to 2 to 20 years. In cause number 25 DCCR 1536, he is charged with evading arrest or detention with the use of a vehicle, a third-degree felony from August 20th, 2025, and because of those same priors, the judge says he would be treated as a habitual offender with a punishment range of 25 years to 99 years or life. Trahan has signed plea rejections showing that the state offered 10 years in each case, all to run concurrently, but he wishes to reject the offers and proceed to trial. The judge makes sure he understands not only the ranges of punishment, but also the possibility that if he is convicted in all 3 cases, a jury could stack the sentences because the offenses occurred on different dates. The prosecutor states that the state will in fact be filing a motion to accumulate the sentences. The judge warns Trahan that after that day she will no longer accept the 10-year plea offer. He could later plead open or to some other number, but not to the same agreement. She then addresses representation. Trahan's current lawyer, Mr. Parker, was court-appointed, but because the cases are going to trial, the judge offers to release him and appoint another attorney who can begin preparing more quickly. Parker informs the court that Trahan already has Ryan Matuska handling a parole matter and would be comfortable with him. The judge says she will look into appointing Matuska if possible. Otherwise, she will appoint someone else from the rotation. Trahan is then returned to the jail while his cases are set for trial. Paul McCorvey appears, next on a state jail felony theft of property charge in cause number. 24 DCCR 1914. Arising from July 3, 2024, his plea colloquy initially resembles the earlier hesitation seen in the Rose matter, though in a less dramatic form. When the judge asks how he pleads, McCorvey stumbles through guilty, not guilty, and no contest, prompting the judge to stop him and insist that he choose clearly. She explains that if he is not guilty, the case can be set for trial and a jury can decide, but if he wants the plea agreement, he must plead guilty and take responsibility rather than merely going through the motions. McCorvey eventually says he is guilty and confirms that he is pleading freely and voluntarily because he did commit the offense. He acknowledges that he reviewed the paperwork, understands it, and knows that if the court follows the agreement, he waives his right to appeal. The agreement provides for 4 years of deferred adjudication probation with no fine, but with $2,500 in restitution and compliance with all standard conditions of probation. The judge finds him competent and finds sufficient evidence of guilt. Because the parties want to proceed that day and restitution is a major component, she waives the pre-sentence report and instead orders a post-sentence report. She defers a formal finding of guilt and places McCorvey on 4 years of probation under the plea agreement. The judge explains the benefit of deferred adjudication. If he successfully completes probation, the case will be dismissed and he will never have a felony conviction on his record. She also warns him of the downside. If he violates any condition, he can be brought back, found guilty, and sentenced to up to 2 years in state jail. The judge stresses that payment of the $2,500 restitution is extremely important, both to her and to the victims, and she orders him to begin making payments immediately. She further encourages him to complete all community service, fees, and other probation obligations quickly because successful performance could lead to early termination of probation. She signs the certification showing he waived his right to appeal and wishes him luck. The court next addresses a defendant identified in the transcript as Maribel Riel Rel, or Mr. Trustee, who has 2 violent felony charges arising from June 19, 2025. In cause number 25 DCCR 0981, he is charged with aggravated assault with a deadly weapon, a second-degree felony carrying a punishment range of 2 to 20 years. In cause number 25 DCCR 0982, he is charged with aggravated robbery, a first-degree felony carrying a punishment range of 5 to 99 years or life. The judge explains both punishment ranges in detail and notes that the state has offered 15 years on each case to run concurrently. Trustee has signed plea bargain rejections and wants to proceed to trial. The prosecutor confirms that the state is not waiting on any additional evidence and does not anticipate changing the offer. The judge warns Trustee that once his case is placed on the trial docket, she will not later accept the same plea agreements. She reminds him that at a prior setting the defense had provided a video or message to the prosecutor and police, but the prosecutor's review of that material did not alter the state's offer. Trustee confirms that he understands and still wishes to reject the deal. The judge then discusses representation. As in Trahan's case, Mr. Parker has been appointed, but the judge offers to release him and appoint another attorney who can begin trial preparation more quickly. Trustee agrees, Parker is released, and the judge states that a new attorney will be appointed and should visit him soon. Trustee also raises the possibility of a bond reduction, but the judge notes that no bond reduction motion has been filed. She instructs him to discuss that with his new attorney, who can file a motion and obtain a hearing if appropriate. Quincy Batley is next. He is charged in cause number 24 DCCR 0995 with unlawful possession of a firearm by a felon, a third-degree felony from June 28, 2023. Batley pleads guilty, confirms that he reviewed the documents with counsel and understands them, and acknowledges that he waives his right to appeal if the court follows the agreement. The judge asks the standard citizenship question. The state's exhibit is admitted, and there is no evidence of incompetency. The court finds Batley guilty and sentences him in accordance with the agreement to 5 years in the Texas Department of Criminal Justice, with credit for time served. As with other firearm-related cases, The judge gives Batley a written admonishment explaining that because of the felony judgment he is prohibited from possessing firearms or ammunition, and that further possession could result in additional criminal charges. She points out that firearm is a legal term with specific definitions and advises him to consult counsel if he has questions about what devices qualify or how long the prohibition lasts. The next plea comes from Lauren Bridges, who is charged in cause number 25 DCCR C0354 with credit or debit card abuse, a state jail felony arising from October 16, 2024. Bridges pleads guilty and confirms that she reviewed and understands the paperwork and the waiver of appeal. The plea agreement calls for a 2-year state jail sentence that will be probated, meaning she will be placed on 5 years of probation and ordered to pay a $500 fine. The judge finds the plea voluntary and resets the case for sentencing so that the probation department can prepare a pre-sentence report. The discussion then turns to Bridges' bond status and personal history. The judge notes that it appears Bridges has prior state jail probations, though they may have been completed successfully. Defense counsel says he previously submitted letters to the court and the state showing that Bridges voluntarily entered rehab at Riverwalk Ranch in August, was released on October 27th, and immediately turned herself in upon release. He says there are 4 letters documenting her treatment and certificates of completion. The judge asks Bridges what her drug of choice was, and Bridges answers that it involved alcohol and both, suggesting alcohol and another substance. In light of the treatment history and the nature of the plea agreement, the judge decides to reduce Bridges' bond to $1,000, though not to a personal bond. Instead, she imposes strict conditions. Bridges must have a drug patch placed within 24 hours of release, and if she tests positive for anything before sentencing, she risks the judge rejecting the plea agreement and imposing a harsher outcome. She must also report immediately to the probation department to start the pre-sentence report, and if she fails to do so or gets arrested again before sentencing, she again risks losing the benefit of the agreement. Bridges says she understands, and the case is reset for sentencing. The final matter in the transcript concerns Travis Smith and an issue not of plea bargaining but of mental examination and competency procedure. Smith is in jail, and his hired attorney, Mr. Adams, has filed documents related to a mental examination. The judge says there appears to be confusion about what exactly the defense is requesting. She first confirms that Adams is retained counsel rather than court-appointed. The judge explains that if the defense is asking the county to pay for a court-appointed mental examination, the request must be accompanied by a sworn affidavit of indigency. Adams responds that Smith is not indigent and that he therefore does not intend to file such an affidavit. The judge clarifies that if Smith is not indigent, then the county will not be paying for the examination. She says that in a retained case where the defendant is not indigent, the defense should arrange and pay for the evaluation itself. Adams suggests he has a form of order and may not be asking for county funds, but the judge repeatedly explains that she does not see why a court order is necessary if the defense can simply hire a doctor or psychologist to examine Smith. She indicates that if the resulting evaluation shows Smith is incompetent, then the court can later intervene and order commitment to an appropriate facility. But the first step is simply to get the examination done. Smith attempts to speak about his confusion, but the judge keeps the focus on the procedure and tells him that she is following the recommendation of his lawyer. She resets the case to give Adams time to obtain the examination, stressing that the quicker it is done, the sooner the case can move forward and the court can determine whether competency proceedings are necessary. Taken together, the entire docket paints a detailed picture of a criminal court that treats plea bargaining not as a mechanical paperwork exercise, but as a serious constitutional event requiring precision, voluntariness, and real accountability. Across every case, the judge carefully explains the charges, the possible punishment ranges, the effects of prior convictions, the meaning of deferred adjudication or probation, the consequences of violating probation, and the rights each defendant is giving up by pleading guilty. She repeatedly asks whether the defendants actually committed the offenses and whether they are pleading freely and voluntarily. When answers are equivocal, as with Terry Rose and Paul McCorvey, she stops the proceeding and forces the defendant to confront the gravity of the decision rather than simply nodding through the script. She is equally exacting with lawyers, openly working through statutory enhancement problems and correcting punishment calculations in real time rather than allowing mistakes to go unaddressed. In Johnson's case, she takes time to sort out whether an unlawful possession charge enhances to a second-degree or first-degree range. And in Ross's case, she refuses to accept an agreed recommendation once she sees how dangerous the new evading conduct allegedly was. Her focus throughout is not merely on docket management, but on ensuring that any plea she accepts is based on a defendant's actual understanding of the consequences and on a sentencing structure that protects public safety. The docket also shows how much of criminal court work happens in the gray space between a plea and a final sentence. Several defendants do not receive immediate punishment because the judge wants more information through a pre-sentence report. For Terry Rose, that report will be essential because the court must later decide